Right. Let us discuss about 31st July 2015 newspaper. In that, the first article is related to National Judicial Appointments Commission Bill, and which is converted into an act now. So, how can a middle path can be found between the executive and judiciary? It is the article is related to. The first to understand this article, let us see what is the National Judicial Appointments Commission does and what are the important provisions related to it. The first thing is the composition. If you see NJAC, it has 6 people. They are three from judiciary, other 3 in one or the other way executive has a role to play. In these 3 consists of CJI plus 2 senior most judges of the Supreme Court. The remaining other 3, one is the law minister who is purely from the executive side, and 2 other are the eminent persons, and these 2 eminent people, they will be nominated by a committee consisting of CJI, Prime Minister of India, and a leader of opposition in Lok Sabha. This is what is the National Judicial Appointments Commission consists of. In this case, the major clause is the entry of executive with regard to the appointments matters, and the second issue is the CJI has no preeminence among the different members who are there in the NJAC. He is made among one among the equals till now whatever the primacy the judiciary enjoyed in the judicial appointments through collegium system is being done away with this. So in this context, let us see how the NJAC functions. All the vacancies, they will be referred to the NJAC in a fixed time frame. For example, if a judge is getting retired, the information has to be shared with NJAC advance of 6 months. And even if a judge resigns or dies, then the information has to be communicated to NJAC within 1 month. Now, the NJAC with regard to the Supreme Court judges, it tries to take the Chief Justice of India based on the seniority and his fitness. So it means he is fit to hold the office is the term used in the NJAC Act. On what basis this fitness is defined? Is it a physical fitness, mental fitness, what it is? Previously, if you remember that Mr. Bhagavati and also what happened during Indira Gandhi era, honesty did not provided for, it was not given due respect with regard to the judicial appointments during the emergency era. Now in this context, so the seniority became a rule with regard to the appointment of the Chief Justice of India after the collegium system has come up. Now seniority is subjected to the fitness with regard to this law. And next is other judges. Here till now the seniority became a major point for their appointment. Here more than the seniority, ability, merit and other criteria specified in the rules and regulations. That is what is the law talks about. And veto power of the members, this is what is the most controversial. If 2 or more members, if they reject a particular person and the person shall not be referred to be a judge of the Supreme Court. The same also applies with the case of the High Court judges. So it means the law minister along with the one of the eminent person, if they can oppose a particular appointment, automatically the executive of the day can get a veto in judicial appointments. So in this context, understand the committee which is concerned with the appointment of the eminent persons, it has 2 politicians, one is from judiciary side. It means politicians may collude to bring in person of their choice into judiciary. Now, if it can be taken forward or by them through the NJAC, in this case judiciary has relatively a little role to play where that checks and balances are not very much imminent. So in this context, this veto power is very much controversial where executive can get its people into play or executive can reject the judicial choices of the people. And with regard to the High Court judges, the procedure starts either from the Chief Justice of the High Court or from the NJAC. NJAC can send a set of nominations or set of preferred members towards the Chief Justice of High Court, or High Court can send nominations to the, or Chief Justice of High Court can send nominations to the National Judicial Appointments Commission. In the process, the Chief Justice of High Court, Governor of the state, the Chief Minister are also consulted, and here also the rule of the veto power applies. So this is what is the controversy over here. In this case, this article provides for certain options over here. The first thing is defining eminent persons very narrowly. So that defining the clear qualifications necessary for eminent persons, so that untoward members do not enter into the NJAC. And second is modifying the eminent persons appointment process, in which the veto power has to be given to the CJI. If CJI rejects that particular individual, he cannot be a part of the eminent persons in the NJAC. The primacy with regard to the selection of eminent persons can be given to CJI. Next is exclusive, the veto power which is there, extending any two members who can reject a particular appointment. It can be confined only to the judiciary. So any of the two members in the judiciary do not agree to a particular appointment, then that can be kept aside. And these are the various provisions. And also it talks about the standard operating procedures for appointments. So these are the provisions that can be in the middle path with regard to the ongoing conflict on NJAC. This is what is the article talks about. And the next is related to the GST, the goods and services tax. The major issues are compensation for the states for the 5 years, and also GST is a destination based tax. That's why the states which have invested in the manufacturing infrastructure, etc., they may lose a revenue. Then how to compensate these states is the second question. And these two issues were resolved where the central government agreed to pay for a full compensation for 5 years, and 1% of additional compensation, additional levy will be levied, which will be used for the compensation of the states with the manufacturing establishments. And the central government also agreed to change the GST governing council composition. That's why the roadblocks were removed. So this bill, once it passes, it benefits the government, it benefits the business, it benefits the consumer alike. So it is seen as the most important progressive financial legislation in the country. Next issue is related to the US South China Sea. You know that Obama's the pivot to Asia. Under this pivot to Asia, the 60% of the total fleet will come under total manpower or fleet will come under Pacific Command. So now the China sees it as a containment of it. So in this context, the Asia is becoming a new zone for the balance of power between these great powers. In this context, recently the Japan security bills, they were introduced they are introduced and they call for collective defense. So it provides for the Japan to intervene with the in the other countries or assist the other countries, even though its interests or the life of its citizens are not affected. It means it is feared that the Japan will be pulled into the war where the US interests are involved. So in this context, Japan has become very critical with regard to the US pivot to Asia. And on the other side is the China and Russia are coming together to balance this US and Japan. Now in this context, if you can remember, Shinzo Abe also is talking about India, Australia, Japan and USA to contain the rising power of the China in Asia. So this is one thing which we need to talk about. But however, India did not show anything explicitly against to China's interest till date. The next issue is right to privacy. So with regard to the Aadhaar, etc., in a recent discussion, Mr. Attorney General Mukul Rohtagi, what he said is, in India there is no explicit statement or explicit right to privacy. So he has quoted certain judgments that is related to MP Sharma versus Satish Chandra, and Kharak Singh versus State of UP. So in this context, it has been said is the Supreme Court has clearly said there is no right to privacy to the citizens in India. So it is argued that the Supreme Court has said or spoke about the right to privacy in these cases in a specific circumstances concerned where the Fourth Amendment of the United States is taken into consideration, where Supreme Court has said such an explicit provision is absent in India. And later Supreme Court has also clarified indirectly under Article 21 the right to privacy. So the major problem in India is we see the right to privacy as one single right, but if in reality the right to privacy is a broad constitutional right which consists of multiple safeguards under it. That is, protecting an individual from search and seizure, and also intrusion into personal property, and also phone tapping. All these things comes under the right to privacy itself. So in this context, a committee was also appointed, that is by the Planning Commission, which has given how a draft law has to be, that is called AP Shah Committee. The AP Shah Committee, it has made an important points over here. What it said is, any privacy law, it shall be technologically neutral. It means that irrespective of the technology, the enactment should provide protections with regard to the information, either it is in digital form or in physical form. So it has to be technology neutral. And the second thing is, the new legislation, whatever it is, it shall protect all the types of privacy. So what are the different types of privacy? One is bodily privacy. It means with regard to the DNA or with regard to the physical privacy or by biometric data. And privacy against surveillance, that is phone tapping, etc. And privacy against the data intrusion or else misuse of the data of an individual. So the privacy has to be, the law has to cover all these three aspects, that is the privacy related to body, privacy against surveillance, and also data protection. So this privacy shall be available both against the government and also at the private individuals. And at the same time, there shall be, the legislation shall provide for proper implementation mechanism to collect and process data, and also proper accountability has to be put in place with regard to the use of this data. So these are the things which are recommended by AP Shah Committee with regard to the privacy. Now, recently, if you remember, there is a DNA profiling bill. This is also in pending in the Parliament. So what is this DNA profiling bill, which is very much related to privacy issues? The first thing is, any criminal event, etc., whatever the DNA material is collected, it will be stored in database. And this DNA is classified based on the crimes or based on the persons, based on the various regions, etc. So which will aid in the criminal investigation process. So now, again, the rights activists, what they call it as is, it is dangerous to the human right and intrusion to the privacy. So this DNA profiling bill in India, let me discuss two more uses. The issues over here are, one is the consent. With regard to the collection of information, do we need to take the consent or not is not very much clear. And how many days this information will be available online? If you take United States of America, the DNA information will be available for 6 years. There is no such a time has been specified. And the third thing is, only in the grave crimes the DNA data is collected and it is being maintained in a data bank. But in India, the DNA profile will be used for multiple uses. That is, if a person identify a dead person, it may be used for rescuing of children who are being after disaster, or it can be used for identifying or solving the paternal disputes. So in these circumstances, when you are keeping it for a wider use, there is also a chance of it being misused. And on the other hand, To what extent it is reliable is also a question posed by some biotechnology experts. Now, if I get my bone marrow transformed, that just sometimes to an extent I may have a DNA which may belong to some other person. So in this context, the DNA profiling as a basis towards the criminal investigation and criminal justice in India, it cannot remain as a foolproof and it will lead to the violation of the justice of the people. So these are the other things which are been coming up related to right to privacy. I just tried to make what are the concepts which are supposed to be covered. What is the international situation related to right to privacy? In India, what are the various judgments given by the Supreme Court? A.P. Shah report on Indian privacy law. So in this context, next is the DNA profiling bill is one thing you can think about. And right to privacy, especially the right to information and right to privacy is another argument. The media and right to privacy. The freedom of press and right to privacy is another thing. So especially with regard to the media overreach which we see these days. So these are the things we need to understand with regard to right to privacy. This year I am expecting a very good question on right to privacy. I don't know how the UPSC is going to frame that, but right to privacy is very much in news because of the Nepal incident. The right to privacy and freedom of press, again that is what is in the news. With regard to the phone tapping issue in Andhra Pradesh, again the right to privacy has come into existence. The DNA profiling bill, the right to privacy is existing. Aadhaar related issues, the right to privacy is in news. On 5 to 6 accounts, the right to privacy is in news. That's why I have a complete knowledge on this right to privacy. And thank you very much. And I felt sick for the last 3 days, so I was unable to upload the video. And I'm sorry for that. And thank you very much. All the best for your prelims. Good night.